Welcome to Sakshi TV special immigration talk show with attorney Ms. Prashanthi Reddy. Please note that Sakshi TV now has 5 immigration shows every week: on Monday with Somi Reddy, on Tuesdays with Kaveti Law Firm, on Wednesdays with Prashanthi Reddy, on Thursdays with Chand Parvatneni, and on Fridays with Banu Nindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call us at 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and for general informational purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need any specific legal advice, please contact the attorney directly. Ms. Prashanthi Reddy needs no introduction, but if you need consultation, you can definitely log on to their website. They have a ton and wealth of free information for the in the hands of immigration community. So you can definitely go contact them if you have any issues regarding your immigration. So without any further delay, let us welcome Ms. Prashanthi Reddy Garu onto our show. Prashanthi Reddy Garu, welcome back. It's so lovely to have you on my show again.
Same here, Shivani. It's great to be back.
Yes. So, Ms. Reddy, today we thought we'll discuss about some do's and don'ts about the H1B cap. But before we get on, are there any recent USCIS updates, or do you want to just go into the topic?
So we can, I just want to update the visa bulletin. The visa bulletin for May was out on the 10th of April, and I don't think we updated that. So just a quick update on the visa bulletin. There's not much of an update actually, because nothing has changed. The dates for filing, the priority dates has not changed for any of the categories, for EB1, EB2 or EB3, for India or China. And USCIS will continue to use the final action date table for employment-based cases, and for family-based cases, they will still continue to use the dates for filing. So just wanted to give a quick update on the visa bulletin. Also, what to expect from the visa bulletin moving forward. We can't expect that there will be too much forward movement. Usually in September or August or September, the visa bulletin, the dates usually retrogress because simply because that's the end of the year. And in October, because the fiscal year starts in October, you will see some forward movement in the visa bulletin, and USCIS will usually use the dates for filing chart in October and a few months after that as well. So we should wait and see if by towards the end of the year, Department of State sees that not enough visa numbers are being used, then they might move the dates forward so that more applications can be filed. But generally that's not the case, so I'm not expecting any huge forward movement in cases. We should wait for that forward movement maybe in October.
Yes. And I think we're done with the updates. Can we get on to the topic now, Ms. Reddy?
Sure, go ahead.
Yes. So now let's go ahead and start our topic again. To all the viewers watching the show, if you have any doubts or if you want to talk to Ms. Attorney, Ms. Prashanthi Reddy, you can definitely give call to the number shown on the screen. Ms. Reddy, let's get on to the topic. Do you want to start with the do's or the don'ts? Go ahead. It's your show now.
Yeah, so the do's and don'ts for H1B, I guess this is H1B season, and people are filing, especially cap cases. All new cases are being filed starting April 1st, and we have to complete all filing by June 30th. So this is when people are actually filing their H1. So I thought it would be good to have a show on how to file, what to do, what not to do, etc. So the first thing is you have to identify your job title and see if it's a specialty occupation or not. Not all job titles qualify for a H1. So the first thing would be to dig deep into your job title and see whether it qualifies. So generally a specialty occupation is an occupation that requires the minimum of a bachelor's degree in a specific field, and also the beneficiary should have that related degree. So, for example, say an attorney, the requirement in the industry is a JD degree, right? So that's a bachelor's degree in law. And since I have that degree, I will be able to file the H1B as an attorney. And also, the requirement in the industry is that an attorney requires a license. So the person filing the H1, for whom the H1 is being filed, needs to have a license in that particular state wherever they're practicing. So it's both. The job has to qualify and the beneficiary has to qualify as well. Now, it's a little tricky sometimes because, for the most common jobs, such as attorneys, software engineers, etc., the Department of Labor has defined what the requirements are. So we don't have to really go and look at the industry requirements. We can just go to the Occupational Outlook Handbook, which is a publication of the Department of Labor, which is available online, OOH. And they have a lot of these commonly used jobs, common jobs, and they have the educational requirements for each of these jobs as well. So that will be a good source for you to start and to see whether your job, qualifies for a H1 or not. Now, if your job is not in that book, you can always go to, commonly available sources on the internet, like DICE, Monster, etc., to see, in general, what does your industry require to hire that person, right? And then you could quote that as well in your letter. Now, it's key to make sure that this is another thing that you have to do is formulate your job description properly. Make sure that the job description is complex enough to require a bachelor's degree in a specific field. If you're going to put in administrative tasks in the job description, then no matter what your job title is, USCIS will not approve it because ultimately they'll look at the job description. So make sure it fits to the job title and make sure that there's no administrative tasks, clerical tasks which don't require a bachelor's degree. So that's very important. In addition to figuring out the job title in your job description, your employer also has to ensure that there is work available for you. A job cannot be filed speculatively, meaning that the employer cannot say that, I will file the H1 now and I'll look for a job later. They have to have a job at the time of filing the H1, and they have to oftentimes present documentation to show that they have that job. So that could be in the form of, the volume of work that they have, the availability of work that they have, maybe describe what the company is, why they need a person of your caliber, maybe submit contracts or volume of business, client letters, client lists to show how much business they have, etc., etc. These are some of the documentation that can be submitted. In addition to that, I think you have to ensure that you are in status, especially if you're in the US. You have to ensure that you're in status to file a change of status from your present status, say it's a B2, an F1, a H4. If you're filing a change of status to a H1, you have to ensure you're in status, and you obviously have to submit documents then to show that you're in status. What kind of documents can you submit? For a H4, you can submit your I-94, you have to submit your I-797 approval, you have to submit your spouse's approval and your spouse's pay stubs to show that they are maintaining their H1 status, and of course the marriage certificate. And what would you submit for an F1? For an F1, it would be an I-20, proof that you're maintaining full-time student status, or if you're on OPT, then your EAD card. These are some documents that you can submit for maintenance of status. For a B2, or if you're on a visitor's visa, then, or an L2, which is a dependent L1 visa, then you simply submit your I-94 documentation to show that, you're in status. Another essential thing to look at is the LCA. Now, the labor condition application is something that's filed by your employer before filing the H1. They file this application with the Department of Labor, and the Department of Labor then approves it. The labor condition application, Once it's approved, it has to be submitted along with your H1B petition. So you have to ensure that the LCA has correct information in it, because you cannot go back and change the LCA information once the case is filed. If there's some incorrect information on the LCA, you'll have to refile the entire case, because the LCA has to be approved before the filing of the case. You cannot file the LCA after the case has been filed. So, you'll have to redo the entire thing. So what's in an LCA? An LCA usually has, the work location, has the salary. These are the two important things in an LCA, and also some attestations as to whether the employer is H1B dependent or not. This relates to how many employees, the employer has on a H1B. So just make sure that all that information is correct. It's signed by your employer and, sent along with the H1B petition. The other thing that you look at always whenever you're filing a H1, especially if it's an extension, or even if it's a change of status, is to figure out how many years you've already been on a H1 for, if you've been on a H1 before, and ensure that you're only asking for the remaining period. So though you can ask for 3 years on a H1, if you don't have 3 years left, then you cannot ask for 3 years. You can only ask for the remaining period. If you ask for 3 years, then they'll send an RFE. Of course, there are exceptions to this. If you have an I-140 approved, if you have a labor pending for more than 365 days, or if you have time spent outside the country while you were vacationing, etc., you can recapture that time. So there's some ways of asking for, extra period of time on your H1, but, those are very limited, and you have to know whether you qualify for that extra period of time or not before you actually file the H1B petition. So that's very important. Another, last but not the least important, is the filing fee. Now, the filing fee has become so complicated over the years, and even more complicated now, because they've added other elements to the filing fee. They've increased the fee. They've added some new fees. Now they've added a $600 asylum fee that employers who have over 25 employees have to pay. And there's different fees for different kind of employers. So it's very difficult to identify what the correct filing fee is and submit it. Now, the good thing is USCIS does have a filing fee calculator, so it's easy to calculate that as long as you have the information with reference to the company. And you can see whether the fee increase applies to you, doesn't apply to you, what kind of fees apply to you, etc. When you have calculated the fees, ensure that you write the correct amount on the checks, you sign the checks, and the checks are dated less than 6 months from now, right? If you have checks that are more than 6 months old, then the bank won't accept them, right? So make sure all that is done, and make sure you submit the correct fee. So that's the fee. Again, quickly, say you followed all these guidelines, but you still get a request for further evidence. What do you do once you get a request for further evidence? First thing you need to do is read that RFE really carefully, because you get only one chance to respond to an RFE. They don't give you multiple chances. Don't panic. Getting an RFE doesn't mean that your case is going to get denied. It just means that they are looking for additional information, and once they have it, they will make a decision. In most instances, if we file the petition correctly, an RFE doesn't lead to a denial. In most instances, it leads to an approval if the RFE is responded to properly. And how do you respond to it? Don't respond in parts. If they're asking for 10 documents, don't submit 5 documents. It's not a choice. You have to submit all the documents that they're requesting for. And I said there's only one chance, so make good use of it. Answer completely to any questions that USCIS has. Make sure you give complete answers to all the questions. Third, make sure that you read the entire RFE. Sometimes there are questions that are embedded into other information that you think is simply boilerplate, RFE information. So oftentimes the officers will put in information into the RFE, which is case law, which states, what the present law is, and not actually what they're asking for. And what they're asking for is the most important part of the RFE. So make sure you read all that and ensure that, you know exactly what USCIS is asking for. Sometimes, unfortunately, USCIS is not clear in what it's asking for. And only a person with experience, an attorney with experience, can figure out what USCIS wants. So it's deceptive often. They will say something, but they'll mean something else. Or they'll they won't tell you exactly what documentation they need. They'll just say, okay, this is the problem, fix it. So you have to know what documentation will actually fix that problem, or what explanation will actually fix that problem. So I think when an RFE is issued, it's important that you contact an attorney who has experience doing US immigration law and doing H1s. Make sure you double check the address that you're sending the RFE to. The address that it comes from is not always the address that it goes to. The address that it goes to is mentioned on the last page of the RFE, and sometimes it's a different address, and they do this for purposes of expediting, RFE requests. So they move around cases based on, which service center has, more caseload. So just be careful if you send it to the wrong address. Even if it is received on time, it might not be accepted. And with reference to receiving it on time, make sure you send it on time. Don't send it in the last moment. If you have the deadline today, be very careful about sending it the day before, because sometimes FedEx or UPS or other courier services may say they'll deliver next day, but something might happen and they may not be able to deliver it next day. So always give yourself enough time, or give, for contingency situations, such as, the RFEs getting lost, the documents getting lost by the courier service or getting delayed, right? Give it enough time. And the last point that I wanted to make is know the difference between RFE and a NOID. RFE is a request for further evidence, and we discussed that it is simply issued because there's some missing documents, and once you submit those documents and that explanation, usually an RFE is approved. NOID, on the other hand, is a notice of intent to deny. And these are issued when the officer thinks that your case should be denied. And they're giving you 30 days to explain why your case should not be denied. So they've already decided that they should deny it, but they've given you one last chance to explain to them why they are wrong or why they shouldn't deny it. So these cases also can get approved because there might be some miscommunication, or might be some error in fact, factual error that they're pointing to that is not actually correct. And once you explain that to them and give them documentation showing it, you might be able to show that this is an error. So that's the difference between an NOID and an RFE. Shivani, over to you. I think if you have any questions, we can take those now.
Yes. I think my first question was that, a lot of these people who want to apply, they generally tend to ignore the updates that come from the USCIS. Sometimes there are pretty important updates coming up, and I feel like there's a new update every single week. So whatever rules were there back in a week, it's not a rule that it's going to be the next coming week too. So how important are these checking these updates? Very important. And also they also do some petty mistakes, like probably it can be wrong date of birth, or it can be the wrong names. I have heard cases that the US has completely rejected everything because of the fact that you're doing such silly mistakes. How should these be avoided, and why are these supposed to be avoided at any cost?
So I guess you have two questions there. One is, how important is it for you to keep yourself updated on the new laws? And it's very, very important for everyone concerned, because remember, ignorance of the law is never an excuse. So if you tell USCIS, oh, I'm sorry, I didn't know that this was the law, and that's why I didn't follow the law, that is not an excuse ever for falling out of status. So you have to keep yourself abreasted with what the law is. You have the internet for that. You have attorneys that you can consult. So always, whenever you, if you're on a certain immigration status, please make sure before you send any case to USCIS, or even in order to maintain your, H1, there might be some new rules that come out. And as Shivani was pointing out, that there's always updates with reference to immigration law. And I, for us attorneys, it's easy because we know which websites to go to. We subscribe to the proper websites. I would suggest you subscribe to USCIS website, and whenever there's a change, USCIS will send you an email, and that's the best way to keep updated. Or contact an attorney, or watch shows like this, the talk shows which Sakshi TV has. That's a great way to keep yourself updated. And extremely important, for example, the fee has changed recently. So much has changed with reference to employment-based law that unless you kept yourself abreast, you wouldn't know what the new requirements are for a H1, what the new fee is, what is USCIS doing with reference to documentation, and the fact that USCIS is now online and a lot of cases can be filed online and they're easier to file. So all this information you may not know, and you may, be doing things the wrong way. So that's very important to keep yourself updated. And secondly, with reference to the second question, is silly mistakes, typographical errors must be avoided at all costs, because unfortunately USCIS has a zero tolerance policy even towards inadvertent errors, unfortunately. So if you send your petition and you didn't sign it, or if you left a column blank and you didn't fill it out, USCIS will just send those cases back, and you might fall out of status because by the time they send it back, you might not be in status and you may not be able to send the package again back to USCIS. So very important that you don't make silly mistakes. And the way we do this in our office, and everybody's human, right? It's possible for anyone to make a mistake. So we have a process that we follow. We have 3 levels of review that take place, and then the client also reviews it. So the more number of eyes that are looking at it, the more likely that the case will not have inadvertent errors. So the important to have a process in place. That's what I'm saying. Whatever your process is. So also in some instances, for example, you were mentioning date of birth, etc. If you put the wrong date of birth, then your approval will come with the wrong date of birth, or your green card could come with the wrong date of birth, right? And then it's really difficult to change those documents or to correct those documents after once approved. So, get it right the first time. It's a very exacting task, immigration law, because there are all these forms that have to be filled out. And so attention to detail is extremely important.
Yes. And also, Ms. Reddy, the one thing that I've also kind of noticed over the time was that if USCIS has any specific request, let's say it's an RFE or whatever it is, if I've also heard that if there is if there is a delay of you reverting them back, there are also chances that they can completely reject it, or it's going to take much more longer. Is it true, or is it better that they just don't wait till the deadline and be like, oh, I still have 10 more other days, I can still do it? Or else is it better for them to do it as quickly as possible?
I mean, it's always, if you have to file it anyway, unless there's some situation wherein you're waiting for some documents or you're waiting for some other information before you can file, right? Unless there's a reason to wait, you don't wait because you're procrastinating, right? That's not the reason to delay your case. You make sure that you file it on time and file it ahead of time, not just on time. I understand that sometimes in some instances there might be a delay because you can't help it because you're waiting for some documents from abroad. Maybe you're waiting for a birth certificate. But in general, we have to ensure that you file earlier rather than later, because yes, these deadlines are all hard deadlines. They don't give extensions. You can't send an RFE saying, please give me an extension. They will simply deny the case if they don't get the response within the date that is on the RFE. So please make sure you respond on time.
Yes.
And also with reference to an I-94, deadline, like if your status is expiring, there is no extra days that you get to file your petition before your status expires. And if your status expires, then you have nothing in the US, right? You have no way of staying here. So don't wait until the last day to send out that extension. Do it ASAP. And it's important that you do it ASAP because if you fall out of status, then it's so difficult to get back into status. You most probably will have to just leave the country. You could say that on nunc-pro-tunc humanitarian grounds, please file. Please forgive me for not filing on time, and say somebody was sick or whatever the reason you have. But then you're under USCIS's mercy. So you don't want that. You want to be able to get an extension based on the merits, not based on the USCIS's mercy. So because that's always unpredictable. So file your petition in time.
Yeah, of course. And finally, Ms. Reddy, I want people to even understand that, whenever someone is applying H1Bs, it's also very important to overlook their dependents also. Also kind of understand if their documents are also correct, or, there can be a mistake. We're humans in the end of the day, like you said. So how important is overlooking for the dependents important again?
So yeah, the H4 dependents, oftentimes what happens, Shivani, is that when the H1 is filed, the employer doesn't ask about their employees' dependents because they're only concerned about the employer. And the employee doesn't know enough to know that sometimes it might just be a mistake that they don't realize that their spouses and children's I-94 is also expiring and they need to file an extension. Or sometimes they think it's not needed. So many people have told me, oh, I filed my H1. I thought that automatically extends my dependent's H4. So ignorance, as I said, is not an excuse. So you better learn about what the law is. You have to file a separate application for your dependents as well to get them in status. And while USCIS might have more sympathy for a H4 dependent status expiration, and when you file a nunc-pro-tunc petition on humanitarian grounds, they're more likely to approve that case than the principal H1 forgetting to file their extension and filing it on those grounds, because these people are dependents and sometimes they're minor children. But again, don't depend on the mercy of USCIS. You might have to leave the country, and separation from your family is not a good thing, right? Your wife and kids might be separated from you for a while. Worst case scenario, if their visa is expired, then they have to go to the consulate as well. Then the officer there will ask them about why they overstayed. And there is also very important, if your I-94 expires and you overstay, there is something called unlawful presence. So as per the unlawful presence law, if you stay out of status for more than 6 months, you're barred for a period of up to 10 years. So you want to make sure that you don't have to face that bar. So there are many reasons to make sure that you don't do things properly and in a timely manner.
Yes. And I really hope that the viewers who watch the show take these points, and if they if they still can't find their answers, I hope they come talk to you, Ms. Reddy, or maybe reach out to your law firm. Thank you again, Ms. Reddy. It was lovely having you on my show today. Have a great week. Thank you for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.
Thank you, Shivani.